today's speaker. I see that we have 78 registrants. The topic for today's public legal education workshop is the Supreme Court of Canada's tax case. What did the Supreme Court of Canada decide? Before I introduce Professor Emeritus and Searle Senior Research Fellow Alistair Lucas, I would like to thank the Alberta Law Foundation for sponsoring this public legal education series. I would like to note that we recognize that the University of Calgary is in the traditional territories of the Treaty 7 peoples, including the Siksika, Piikani, and Kainai nations, the Blackfoot Confederacy, the Tsuut'ina, and the Stoney Nakoda, including the Chiniki, Bearspaw, and Wesley First Nations. What is now the city of Calgary is also home to the Métis Nation of the Alberta Region 3, situated on lands adjacent to where the Bow and Elbow rivers meet. Secondly, normally at this time, I announce the next Saturday morning at the law school workshop, which was previously scheduled for June. However, due to some construction on campus next month that may interfere with our Wi-Fi system, whether or not we have another Saturday morning at the law school session next month is up in the air. So please stay tuned. If you're on our mailing list, you will receive an update. We have a topic, we have a speaker, but as I say, due to some construction complications, it's unsure whether or not we'll have one. If we don't, then there may be one either later this summer or a couple of sessions in September. So with that in mind, Professor Emeritus and Senior Research Fellow Alistair Lucas, he's a former Dean of the Law School and an adjunct professor of environmental design at the University of Calgary. He served as an acting member of Alberta's Energy Resources Conservation Board, a policy advisor at Environment Canada and Climate Change, and director of the Sustainable Energy Development Program, an interdisciplinary MSc program at the U of C. His current research focuses on regulation of interprovincial pipelines and GHG emissions and the legal responses to energy sector impacts. And so he's an ideal person to enlighten us on what the Supreme Court of Canada decided recently regarding the Federal Greenhouse Gas Pollution Pricing Act. And with that, I will turn it over to our distinguished speaker this morning. And as usual, we'll have our question and answer period after our break at 11. And again, we would ask everyone at the end of today's session to complete the electronic evaluation forms that our co-moderator, Catherine Owood, will be sending out after the session. And again, today's session will be recorded and will be uploaded after the workshop today. So with that in mind, Professor Lucas.
Good morning, everyone. The focus this morning will be on the reference case concerning the Federal Greenhouse Gas Pollution Pricing Act that the Supreme Court of Canada released in March of this year. What I want to do is focus on the case itself, that is a little bit of the background to how it got before the Supreme Court of Canada, what the court actually decided, how the court reached its decision, and a little bit about the implications of the court's decision. So beginning with a bit of the background, this was a reference case, and a reference case is one in which the government of either a province or the federal government refers a legal question to the, in the case of provinces, to the Court of Appeal in the province, and in the case of the federal government, it can be directly to the Supreme Court of Canada. This case resulted from 3 provincial references. Ontario, Saskatchewan, and Alberta all referred the question of the constitutional validity of the Greenhouse Gas Pollution Pricing Act to their courts of appeal. And you can see on the screen that the results of the 3 cases. The Ontario Court of Appeal held that the statute was constitutionally valid. Saskatchewan likewise. The Alberta Court of Appeal, however, in a split decision, and these were all split decisions of the judges, but the Alberta Court of Appeal held that the act was invalid, and capturing just a little bit of this, the majority opinion referred to a constitutional Trojan horse that this statute represented. So this is the background. On further appeal, these cases were consolidated before the Supreme Court of Canada, and that is the Supreme Court of Canada decision that we're looking at this morning. Just a note, you can see on the screen, I've referred to 3 A-blog posts by my colleague Nigel Banks and Martin Oshinsky, along with U of A professor Andrew Leach. They have looked at the case and the background to the case in much more detail than we'll be able to do this morning. And I commend this to your attention. If you haven't looked at the A-blog faculty blog, you might want to do that anyway, but you can get that by going to the University of Calgary Faculty of Law website or directly to a blog. So I'm going to begin with reaction and then from there go to the case. So Premier Jason Kenney, you get the picture. Federal Conservative leader Erin O'Toole. He doesn't want to talk about the case at all. He wants to talk about the Conservative Party position on this matter. And he wants to be quite clear that no. For us, this is not a carbon tax. It's a pricing mechanism. And he's not the only one among the political leaders who's been very wary about calling the subject of this legislation a tax. Various terms have been used. Charges, levies, pricing mechanisms. But again, you get where Erin O'Toole is coming from. Jonathan Wilkinson, the federal environment minister, who says the debate about carbon pricing is now over. Well, not exactly, because particularly of a mechanism in the act, the backstop part of the act, really puts the ball into the provincial court or into the provincial governments to decide whether they want to negotiate with the federal government about the application of the federal act within their provinces. Okay, and if they do nothing, the federal statute applies, but the statute itself provides for the federal government recognizing provincial greenhouse gas pricing legislation as equivalent to the federal. And if that kind of agreement is reached, then the provincial legislation continues in force, not because of provincial constitutional powers, but simply because of the backstop provision of the federal act itself. Okay, so Minister Wilkinson is getting a little bit ahead of himself here. He is not thinking about what he and his cabinet colleagues in the federal government will have to do and what they're doing right now to implement the Supreme Court of Canada decision. So, two quotes from the majority in the case and the minority. So the majority, Chief Justice Richard Wagner, so he says climate change is real, caused by greenhouse gas emissions resulting from human activities, and it poses a grave threat to humanity's future. Okay, so a judicial recognition that this is the foundation for the federal legislation. Climate change is real. And one of the things that that kind of statement does is at least set a basis for potential future greenhouse gas emission litigation, and more broadly, climate change litigation based on what government in Canada is doing or not doing to address climate change. To this point, cases of this kind have not got very far, either in Canada or in other countries, with a couple of exceptions, because courts have been prepared to say, well, the emissions in our country are a tiny part of the global greenhouse gas problem. And as a result, what's going on in our country and what our government has done is really de minimis. But this kind of statement, at least by Chief Justice Wagner, goes some way toward a recognition that this really isn't the case, that this is a global issue posing a threat to humanity. But, and he went further to indicate that this is something that, of course, shows up within countries, within Canada. So environmental lawyers are looking at these statements with great interest, thinking about potential future climate change litigation. Okay, so Chief Justice Wagner says the result is not to limit provinces' freedom to legislate, but to partially limit their ability to refrain from legislating pricing mechanisms or to legislate mechanisms that are less stringent than would be needed to meet the national targets. The national targets being linked to international climate change commitments, particularly the Paris Agreement. So what he's doing there is making clear that the Supreme Court of Canada decision is not removing provincial jurisdiction to deal with this issue completely, but only partially. and recognizing federal jurisdiction to deal with the issue to the point at least necessary to meet national targets. So trying really to downplay the impact of this decision on provincial constitutional jurisdiction. The minority, Justice Russell Brown, on the other hand, you can take a look at his language here. So he's talking about federalism, about the model of federalism that we have in Canada. And he thinks that the majority decision rewrites the rules of confederation and is bound to lead to serious tensions in the federation. So maybe that's overstating it, but that was his perspective on the majority judgment. He says its implications go far beyond the act opening the door to federal intrusion by way of imposition of national standards into all areas of provincial jurisdiction, right? And he refers to trade and commerce, health, management of natural resources, among others. So Justice Brown is portraying this as a sort of slippery slope, guaranteeing an extension of federal jurisdiction at the expense of the constitutional jurisdiction of provinces. But what I'd like you to see, looking at these quotes, is that these really represent different visions of the Canadian Federation and the Canadian Federation as expressed in the Constitution Act 1867. And we'll see more of this as we go along. But fundamentally, these differences explain the different results in the majority judgment and the minority judgment. Justice Brown wrote the main minority judgment. There were two other minority judgments. Justice Suzanne Cote dissented, and she dissented on the basis that the that the Greenhouse Gas Pollution Pricing Act contains too much discretion, too much federal government discretion, to the point where fundamental decisions can be made by the federal government by way of regulation rather than decisions based on the act itself. And so her fundamental concern is the idea of governmental discretion unchecked rather than structured and limited by legislation. A very interesting point, and one that we're going to see more of perhaps, but this line that she took led her to the conclusion that the act, structured in very broad discretionary terms, could not fall within federal legislative powers under the Constitution. Otherwise, apart from the discretion element, otherwise, she was in agreement with the majority. The other judge in dissent, Justice Rowe, had a different approach as well. He had a different approach to interpreting the Constitution Act 1867 that led him to put more emphasis on the provincial heads of power under the Constitution Act, and that led him to the conclusion that the federal act was ultra vires, the government of Canada. So those are the three minority judges, and I'm going to focus on Justice Russell Brown's judgment, because among the minority judges, he's really the only one who wrote a full judgment addressing all of the issues and joining issue with the majority judgment in the case. You might be interested to know that there were two judges who have connections to the West. Justice Brown and Justice Sheila Martin. And in fact, both of those judges have connections not only to Western Canada, but to law schools in the West. Justice Martin, former dean and professor at the University of Calgary Faculty of Law, and Justice Brown was a professor at the University of Alberta Law School before his appointment to the Supreme Court of Canada. But you'll notice that they were on different sides. So the idea that Western judges are bound to line up as champions of provincial rights doesn't really figure very prominently in this decision. Okay, a few more quotes. The business and financial community, markets like certainty, absolutely. Whether they've got complete certainty as a result of this decision, however, is another question. Federation of Independent Business, basically saying big business is going to be happy with this decision. Small business, maybe not so much. Down at the bottom, Andrew Gage, West Coast Environmental Law, makes it clear. He says the buck stops with the federal government. Canadian government must work cooperatively to encourage provincial action, but it can also step in when provinces fail and take the steps required to protect Canadians from climate change. So Andrew Gage is basically saying, okay, it's over now. The federal government has commanding constitutional jurisdiction, and yeah, they'll have to work with the provinces, but essentially the federal government is now in the driver's seat on this subject. Okay, so some of the perspectives on the decision. Now I want to move to what question did the Supreme Court of Canada actually decide? And in the media reports of the decision in the case, this is something that was usually not very clear. References were made to climate change and to greenhouse gas emissions, to what the governments had done previously to deal with climate change. But there was a lack of clarity about what question the court actually decided. So the reference cases were all about the question, is the Greenhouse Gas Pollution Prevention Act constitutionally valid? That was the fundamental question that the provincial courts of appeal had to deal with, and that was the question before the Supreme Court of Canada. It was not which level of government can legislate on climate change. Okay? That was a broader question, and as such was really not a matter before the court. The question before the court was much more specific. right? So the focus is on the act and precisely what the act says and what it requires. So the court had to look at and come to a conclusion about what is the subject matter of the act. What is the act about? And we'll look at that a little more closely in a few minutes. That's the first question that the court had to grapple with. And the second part of this is, having determined what the act is fundamentally about, does the act fit under one or other of the federal constitutional powers under the Constitution Act, or does it fit under one of the provincial powers? So it's really a two-stage analysis. What is the essence of the act? What is the term that lawyers sometimes use is the pith and substance of the act? What is the subject matter of the act? That's the first question. And having decided that, the next question is, does it fit under one of the federal constitutional powers or one of the provincial constitutional powers under the Constitution Act 1867? So what does the act actually say? There's a preamble that refers to global climate change, background about what the Canadian governments have done, about what science has determined about human and ecosystem risks, the idea that immediate action is required and that governments around the globe seem to be united, at least in a broad sense, on that greenhouse gas pricing is a core element of necessary behavioral change. Okay, so all of that shows up in the preamble to the act. There are two parts to the act. Part one imposes a fuel charge on sellers of defined greenhouse gas producing fuels. So this is a classic carbon tax, even though the act doesn't use the term tax. Okay, and it's imposed on sellers who can be individual persons, can be corporations. Okay. Part two imposes what is described as an output-based pricing system on a specified group of large greenhouse gas emitters. The term that is used in the act is compensation for excess emissions. That sounds vague as anything, okay? By a covered facility, and a lot of the act is concerned with defining the facilities that are subject to the requirements of the act. Okay, covered facility that emits greenhouse gases in a quantity that exceeds the emissions limit that applies to that facility. Okay, so you can see that the second part, part two, is targeting large emitters. And where are large emitters to be found? They are found within provinces. So these are industrial operations within provinces that are producing greenhouse gases. The third thing to remember about the act is that it applies only to provinces that have greenhouse gas pricing legislation that the federal government considers not to be equivalent to the federal minimum pricing standard. Right? If a province has legislation that is regarded by the federal government, and there's a discretion there, as equivalent, then an agreement will be entered into, an equivalency agreement will be entered into, and the provincial legislation will continue to apply. If the provincial legislation does not meet the federal standards, then, and this is the backstop element, the federal act kicks in and applies within that province. So those are the elements of the Greenhouse Gas Pollution Pricing Act. The next question is, what does the Constitution Act say? The Constitution Act 1867 divides legislative powers between the federal government and the provinces. It talks about matters coming within classes of subjects, okay? So subject matters, greenhouse gas emissions, for example, coming within classes of subjects. And the classes of subjects are those that are enumerated under sections 91 and 92 of the Constitution Act 1867. So 91 is the federal provision, and it refers to federal powers, including laws for the peace, order, and good government of Canada. And those words are significant in relation to all matters not coming within the classes of subjects by this act assigned exclusively to the provinces. So focus on the not coming within the classes of subjects assigned to the provinces under section 92. So that language suggests a residual power in the federal government. If you look at section 92, it lists provincial powers, including property and civil rights in the province, local works and undertakings, non-renewable natural resources, okay, and as I mentioned, those provisions have been interpreted to provide a residual power to the federal government. That is, subjects that are not mentioned, do not come within the section 92 provincial powers, ultimately fall to the federal government. But it's not quite as straightforward as that, because there is potential for provincial laws and federal laws that appear to deal with the same subject matter, both being valid as within federal powers on the one hand and provincial powers on the other hand. What is going on there is that the governments are coming at these issues from different perspectives in constitutional terms. And the term that the courts have used here is double aspect. So there can be a provincial aspect to greenhouse gas emissions, and there can be a federal aspect to greenhouse gas emissions, both of which can fit under either provincial powers or federal powers. So what happens then? If the two statutes do not come into conflict, then they can simply operate. Both will be valid. If they conflict, however, then the federal statute will override. And the term that's used is paramountcy. The federal statute will be paramount. Now, in this case, there was no discussion, directly at least, of this idea of concurrent federal and provincial legislation and paramountcy, because there are undoubtedly provincial greenhouse gas emission statutes in force already and have been for some time. There is certainly in Alberta, we've had legislation of this kind for over 20 years. Right now, the act is called the technology, I've got to get this right, the Technology Innovation and Emissions Reduction Implementation Act. And then there's a set of regulations under that act called the Technology Innovation and Emissions Reduction Regulation. TIER is the acronym that is used. So we have legislation in Alberta that is broadly similar to Part 2 of the Greenhouse Gas Pollution Pricing Act already. Okay? But the constitutionality of that was not an issue in this case. So the decision here says nothing directly about the constitutionality of the provincial legislation. A number of years ago, Professor Nigel Banks and I studied the constitutional validity of the predecessor legislation to the provincial act I just referred to. And our conclusion was that, yeah, it's constitutionally valid. And the current legislation very likely is constitutionally valid as well. Okay, but you have to bear in mind that this was not an issue in the Supreme Court of Canada's decision. The other thing to keep in mind, and this might come perhaps as a bit of a surprise, is that the federal government very likely could have passed different legislation that could have been held constitutionally valid under different heads of federal constitutional power. It could, for example, have been a carbon tax, a general carbon tax with the tax revenues going into general revenue. And it would undoubtedly, in my opinion at least, have been valid because one of the federal powers is any mode or system of taxation. Okay, very, very general. The problem with that is that the Greenhouse Gas Pollution Pricing Act takes the tax revenues and returns them to individuals within provinces. And this is something you will have noticed on your 2021 tax return. Those funds do not go into general revenues, and the courts have held that in order to be taxing legislation, that is what has to happen. Otherwise, the legislation is regarded as regulatory legislation. But that could have been done by the federal government, a general carbon tax. There is also a federal power in relation to criminal law, and that has been very broadly interpreted to support federal legislation that includes criminal prohibitions and penalties. And this Greenhouse Gas Pollution Pricing Act also has prohibitions including indictable offenses and penalties, including potential jail time, if you look at the enforcement parts of the act. And one of the decided cases of the Supreme Court of Canada the Crown-Zellerbach case that dealt with pollution of marine waters in Canada. The Canadian Environmental Protection Act, which is the main federal regulatory statute, was upheld in that case based on the criminal law power. So after that case, many constitutional law scholars, and I was among these, thought that there was jurisdiction under the federal criminal law power to support greenhouse gas emission legislation, including pricing legislation. But the act was not framed with constitutional support under the criminal law in mind, and the court approached it in that way. And the engagement in the provincial courts of appeal raised this almost incidentally as a possibility, but the Supreme Court really didn't address the criminal law power at all. But what I'm suggesting is that there's at least a plausible basis under the criminal law power that's been held to support the Canadian Environmental Protection Act, or the Canadian Environmental Protection Act. And under the Canadian Environmental Protection Act, greenhouse gases have been listed in the schedule to the act as a toxic substance, and as such can be the subject of regulations. So a system of greenhouse gas emission pricing could have been crafted and implemented under those regulations. And those regulations, at least the schedule to the act, was already in effect. So that could have been done as well. Okay, so I wanted to make it clear that there were other possibilities here, and some of them quite plausible possibilities for federal constitutional jurisdiction to support the Greenhouse Gas Pollution Pricing Act. So let's look at the constitutional analysis that the court undertook. As I mentioned, there are two steps. Characterization, and that is the court asking the question, what is the pith and substance? What is the subject matter? What is the act all about? This was the majority's conclusion. And you can see what the majority looked at. International activity, ratification of the Paris Agreement, and nationally, the pan-Canadian approach that the federal government had developed to establish national pricing standards. Okay. So that's the majority, what the act is about, not regulation of greenhouse gas emissions generally. The focus is on pricings. And the majority recognized that there's harm associated with a purely intra-provincial approach. So the conclusion of the majority was that the pith and substance of the act is establishing minimum national standards of price stringency. So notice, minimum national standards and price stringency. So it's about pricing greenhouse gas emissions. That was the majority characterization. The minority, on the other hand, this is Justice Russell Brown, said this. Okay. So he took a different tack. He said, you have to characterize parts 1 and 2 of the act separately. So he said part 1 is all about reduction of greenhouse gas emissions by raising the cost of fuel, right? So it's fundamentally a carbon tax. He didn't say that specifically. The pith and substance of part 2, he said, is the reduction of emissions by pricing emissions in a manner that distinguishes among industries based on emissions intensity and trade exposure. And so his conclusion is that the pith and substance is reduction of greenhouse gas emissions, and you need to add there by means of pricing measures. So he conceded that, yeah, the act is about greenhouse gas emission pricing, but fundamentally it's about the reduction of emissions. Okay, nothing about national standards, you'll notice. So the court begins by splitting in this way on what the act is all about. And you'll see that this difference in characterization figures in the next part of the analysis, that is looking at the heads of constitutional power. And Justice Brown's dissenting judgment can be explained to a considerable extent on this basis. He was really trying to fit something different within heads of constitutional jurisdiction, federal or provincial, than the majority was. The other thing to notice about characterization here is that the majority's characterization is narrower than that of the minority. And in principle, at least, that makes it easier to find a head of federal legislative jurisdiction that doesn't intrude unduly into heads of provincial jurisdiction. If it is a broader characterization, as Justice Brown has made, this increases the possibility that the subject is going to intrude into provincial jurisdiction. So the characterization stage of this analysis is really vitally important. So let's look now at classification. This is the next step. We're taking the characterizations and we're asking, what heads of federal or provincial power do these subject matters fit under? And the majority concluded that no enumerated federal or provincial power really is appropriate. That then pushed the majority to focus on the peace, order, and good government power. That is the residual power that the federal government has under the Constitution Act 1867. And that is really the rest of what we're going to be looking at as far as the constitutional analysis is concerned. The minority, on the other hand, Justice Brown, said clearly within provincial powers. Property and civil rights, matters of a local or private nature, non-renewable natural resource, provincial jurisdiction. Okay. For the minority, that would have been the end of the analysis. It's within provincial powers. That's it. Right? There's nothing left for the federal government under their enumerated powers or under their residual powers. But the minority, nevertheless, did engage on the peace, order, and good government power simply because they had to do that. They had to come to grips with the analysis that the they had to come to grips with the analysis that the majority had developed. Okay, sorry. So the core of the court's analysis focused on the peace, order, and good government power, and this is the federal residual power under sections 91 and 92. And the analysis that the courts have developed in previous cases require that these things be considered. Is the subject matter one of national concern? Secondly, is it single, distinctive, indivisible? In other words, is it specific enough? And thirdly, is it of a scale of impact on provincial powers that doesn't intrude too much into provincial powers? Is it consistent with the general division of constitutional jurisdiction under sections 91 and 92? These are the steps in the court's analysis. So, national concern. This is what the majority said. Okay, so matters that transcend the province owing to their inherently national character. Are they this matter of greenhouse gas emission price stringency, minimum standards for that? Is this a matter that goes beyond the constitutional jurisdiction of the province? Is this something that is inherently national? And the majority looked at the Paris Agreement, looked at the Canadian framework, the science and scientific reports on greenhouse gas emission issues, and this was the conclusion. This is of national concern. This is of concern to Canada as a whole. This matter is critical in our response to an existential threat to human life in Canada and around the world. As a result, it readily passes the threshold and warrants consideration. And he ultimately concluded it did more than that. It is a matter of national concern. Okay. So you need to think about provincial focus or extra provincial focus, the extent to which this matter is something that is outside provinces, outside things that provinces can deal with and deal with effectively. This is the minority on national concern. So what is Justice Brown talking about here? He says the majority accepts that provinces have the jurisdiction to do precisely what the act does. Well, not exactly. The majority recognizes that under the backstop part of the legislation, the federal government can recognize provincial legislation as equivalent. But the other way of looking at this is that that's simply a function of the federal act supported by federal jurisdiction operating, not a recognition that the province has constitutional jurisdiction. Okay. And he talks about the idea that something else is going on here, that some aspect of the act is truly and distinctly national in scope and lies outside provincial jurisdiction, which can be regulated by Parliament under the POGG power. And he says, while these submissions are premised on what I have explained is an inadequate description of the pith and substance of the act, right? So he's referring particularly to what he said about Part 2 of the act and the fact that Part 2 of the act deals directly with emissions of particular industrial operations within provinces. And that cuts into provincial jurisdiction, that's property, that's civil rights within provinces. So as I mentioned, the characterization is very important at this stage of the analysis. And he says, I now turn to show that this view is unsustainable on the court's jurisprudence. One of the things to keep in mind is that the court had to analyze previous cases dealing with the peace order and good government power. There aren't very many of these cases, but they're instructive, and analogy is important in this kind of analysis. So for example, the peace order and good government power has upheld federal legislation dealing with aeronautics, radio communication, and now a much more extensive, broader than radio in 1930, but communication of that nature, atomic energy, marine pollution, as I mentioned, under the Crown-Zellerbach case. These were all cases in which federal jurisdiction was upheld under the peace order and good government power. And the Crown-Zellerbach case, in fact, is the origin of critical part of the legal test for jurisdiction under the POGG power that we'll get to. there's something else that's lurking in the background here, and that is there's been debate to a limited extent in the court and among constitutional scholars about what recognition of a subject matter, whether it's aeronautics, atomic energy, marine pollution, as federal jurisdiction under the peace, order, and good government power, what does that really mean? Does that mean that, in effect, a new head of provincial or federal constitutional jurisdiction has been created? And some of the language in the earlier cases referred to that jurisdiction being plenary, that is, all encompassing, if it's a matter of aeronautics, if it's a matter of atomic energy. And if that's the case, then there's really no room at all for provincial jurisdiction. Once this kind of peace, order, and good government based head of federal power is recognized by the court, that's it. There's no possible room for provincial jurisdiction, and certainly not in the in the concurrent jurisdiction mode that I mentioned previously. So there was concern that this kind of transfer theory would have the effect of moving all manner of greenhouse gas emission legislation, in fact, all manner of climate change legislation, over to the federal government. And the provinces would be shut out completely. It turned out that the majority, in our case, did not accept this idea that peace, order, and good government power jurisdiction is plenary in this sense, and there's room for federal and provincial legislation to operate concurrently, at least in principle. Okay, and so all of this goes ultimately to existential threats to provincial jurisdiction, the kind that Premier Kenney was very worried about. Okay.
Professor Lucas, hi. I'm sorry to interrupt, but it is just after 11, so I think this would be a good time to take our scheduled 10-minute break. So why don't we all reconvene in 10 minutes at 11:13?
Okay, thank you.
Al, are we ready to go?
Okay. So are we ready to resume then?
Yes, absolutely. When ready.
Okay, let me pick it up from here then. This is the second part of the legal test that has to be applied to determine whether the act can be supported under the federal peace, order, and good government power. Okay, national concern is the first element, and the second element is what has been described as threefold: singleness, distinctiveness, indivisibility. So you can see that these factors are getting at how specific and how finely tailored the legislation is, with a view to minimizing intrusion on provincial powers. So this is what the majority said. They pointed to the type of pollutant, the global nature of the problem, and the way the act is structured, the price mechanism and the backstop approach. Okay, all in terms of singleness and distinctiveness. But Chief Justice Wagner did something a little bit different in this case than the court has previously. He said there are two principles here that both have to be met. He said, for one thing, the legislation should be qualitatively different from matters of provincial concern. So you can think of, is there a particular national interest that can be identified? Is this something that's of concern to Canada as a whole? And of course, climate change is a global problem. Greenhouse gas emissions are a global issue. He also said that singleness, distinctiveness, indivisibility in previous cases have been approached by the court in terms of provincial inability. Okay, so the court has asked the question, are provinces constitutionally able to address this issue? Provincial inability. So he said, looked at that way, the legislation should be qualitatively different from matters of provincial concern. And secondly, again, in terms of provincial inability, of a nature that the provinces jointly or severally would be constitutionally incapable of enacting, and the failure to include one or more provinces or localities in a legislative scheme would jeopardize the successful operation of the scheme in other parts of the country. And in addition, he said, provincial failure would have grave extra-provincial consequences. So he's pointing to the concern that if left to the provinces, not all provinces would be on board. And if all provinces weren't on board, would it be a situation of provincial inability to address the issue completely? Okay. And this is an approach, this idea of provincial inability. It had been referred to in previous Supreme Court of Canada cases as indicative of provincial ability to deal with the issue, but it had never been treated as as a legal analytical criterion. So there's been quite a bit of discussion about this and how it played out in this case. So that's the majority on singleness, distinctiveness, and indivisibility. And the minority said, well, no, provinces are not unable. Emissions can actually be connected to source provinces, and therefore they're divisible. This is not a matter of indivisibility. They actually emissions actually are divisible. If you think about that, the only problem is that there was no particular evidence, and there could be no particular expectation that all provinces, or enough provinces to actually address the problem fully, would act. And simply saying that, well, the matter of emissions is divisible, and therefore the indivisibility criterion is not met, really doesn't say very much in the circumstances. And Justice Brown also said there's no compelling evidence that uniform treatment is essential to address carbon leakage concerns. And in other words, yeah, some provinces might not get aboard, and emissions from those provinces would rise unchecked, but there's really no evidence that that would be the case, right? They may actually be able to agree. They may be able to get together. So the minority seems to be prepared to take it on faith that there's a good possibility that provincial agreement could be reached. One of the problems here is that this test has to do with effects on other provinces. That is, if Alberta fails to act on greenhouse gas emissions, for example, and other provinces are affected, downwind provinces, but more generally, provinces elsewhere within Canada are affected. Are they really in a position to deal with that situation as a matter of constitutional jurisdiction? So the court sparred, you can see, about this matter of singleness, distinctiveness, indivisibility. The minority thought, well, no, the federal act is not single, distinctive, is not specific and targeted enough, and you really can't say that the matter is indivisible. Okay, and the final factor is this matter of scale of impact on provincial jurisdiction. So the test here is whether the federal legislation intrudes too much into provincial jurisdiction under Section 92 of the Constitution Act. So take a look at the majority view. So the majority thinks, well, no, not undue impact on provincial jurisdiction. The provinces can legislate. In fact, the provinces can legislate higher emission pricing standards if they want to, as long as this meets the minimum national standards of price stringency. So the majority is drawing a line and saying, in effect, that federal jurisdiction can go to the point of minimum national standards. Beyond that, it is up to the provinces, and they still have room to legislate. And so there isn't an undue intrusion on provincial jurisdiction. This is what the minority said, however. So the minorities is saying, get real. You, the majority, are saying, yeah, the province has legislative jurisdiction that ends with federal minimum standards. And Justice Brown also points out that the federal benchmark price can be raised continually. So there's going to be continual pressure on provinces. And so he points to the as long as in Chief Justice Wagner's judgment, and says, in effect, that's really meaningless, because the majority is drawing a firm line at minimum standards. So so that's the analysis and the conclusion that the Greenhouse Gas Pollution Pricing Act is constitutionally valid. So the question is, what now? This act has actually been in force in Alberta since January 2020. It came into force under the backstop mechanism of the act, and is in force as far as it's in force as far as Part 1 of the act is concerned. On Part 2, however, the Alberta legislation continues to be effective, and there's been an agreement reached on that. So the concern about Alberta jurisdiction to regulate in industrial emissions of large emitters, who are primarily energy industry operators, is still within the provincial legislation under the backstop provisions of the act. But on the general carbon emissions pricing regulation, it's the federal legislation that applies. And you can bet that this irritates Mr. Kenney a great deal. Not that Mr. Kenney doesn't have other things to irritate him right at the moment, but this is certainly one of them. So what can Alberta do? And particularly in view of the oil and gas industry in the province and the oil sands accounts for about 11 or 12% of national greenhouse gas emissions. And right at the moment, there's little chance of those emissions decreasing significantly. There are lots of good ideas and initiatives that have been taken, particularly on the carbon capture and sequestration side of things. But a lot remains to be seen about how those technological fixes will actually work and how effective they will be in the longer run. So I would welcome your ideas on what Alberta should do in the circumstances.
As
Catherine?
always, wonderful presentation, Professor Lucas. We have some questions coming in currently. So the first question, one of the earlier slides noted the basis of the majority decision of the international impact of GHG emissions and climate change, noting the Paris Accord. They did not appear to take into consideration that Canadian emissions are only 1.6% of the world's GHG emissions. Could you please speak to that?
The majority judgment, as I pointed out, recognizes, in fact, the Chief Justice makes a point of recognizing that climate change is a global problem, that greenhouse gas emissions are a global issue, not a provincial or even a national issue. And for that reason, need to be dealt with, are a matter that need to be dealt with within Canada. And more than that, if you look at comparisons of greenhouse gas emissions as a function of population, Canada is actually right up there within the top 3 or 4. So it depends on the perspective that you take to this, whether it's a global perspective only, or whether you look at it as something that is a global issue, but ultimately needs to be dealt with by the actions of individual nation states.
Great, next question. Can the federal cabinet's assessment of a provincial equivalency be subject to judicial review, or is it protected?
There's essentially a discretion there. This would be a tough judicial review, given that given that there would be a range of factors to be taken into account, particularly effectiveness. And effectiveness would have all kinds of perspectives to it. These kinds of judicial reviews, in my experience, are unlikely to be successful unless there is a situation in which some factor that in a direct common sense way has significant application to the decision has not been taken into account. I'm thinking, for example, about some of the pipeline litigation and the idea that endangered species implications, particularly killer whales, had not been taken into account in the decision making ultimately by the federal cabinet on the Trans Mountain Expansion pipeline. Clearly, a situation in which a matter that is obviously relevant had not been taken into account. In this case, it's difficult to see that arguments could be developed in that way. And in the absence of that, courts are very reluctant to try to second guess discretionary decisions of this kind. That, by the way, is where the concerns of one of the minority judges, Justice Cote, comes in, right? So that's the kind of thing that she was concerned about, the very broad and open-ended discretion that the Act gives to the federal cabinet.
Great question, Professor Laidlaw. All right, this next question. Can a province enact valid equivalent GHG pricing for consumers without rebating the revenue to its residents?
Yes, it can. Yes, it can. And in fact, under the NDP government, that's essentially what we had. And you may recall that during the last provincial election campaign, that was one of the major UCP promises, that we will repeal the NDP climate change legislation. And that was the first thing that the government actually did. That was bill number 1. And that was one of the concerns that that the UPC government has had with that legislation. They were not satisfied with the way those revenues were being used by the provincial administration at the time. But yes, absolutely.
Great. We have one more question in the chat. And at this point in time, if there's anybody else that has questions, I ask you to please type them in the chat at this point. So the question is, will the decision of the SCC in this case have an impact on the Alberta Court of Appeal's current deliberations on the reference regarding the constitutionality of the Federal Impact Assessment Act?
Well, that's interesting. It's it's a different question. The previous cases on constitutionality of federal EIA legislation have focused on the idea that federal jurisdiction arises, federal EIA jurisdiction arises from federal jurisdiction in relation to particular subject matters, right? Fisheries being the major one, right? And explaining why the Fisheries Act has been so significant in resource development decisions, but there is a bit of the judgment in the Friends of the Old Man River case on the predecessor federal environmental assessment legislation that suggests that the legislation could fall under the peace, order, and good government power simply because environmental assessment is a process, and it's essentially an administrative process that focuses on the matter in issue, but in a broad enough way to address relevant matters of the environment and environment protection. And the implication being that it's only the federal government that's in a position to take that kind of broad view and broad approach and be able to deal effectively with environmental issues raised by projects through environmental assessment processes. So it's possible that peace, order, and good government could play in the decision on the Impact Assessment Act. I kind of doubt that. I think it's going to come down to the court looking at federal jurisdiction in terms of derivative jurisdiction in relation to environmental assessment that pertains to fisheries, pipelines, etc.
Thank you. The next question in the chat. Is there a way for the provinces to appeal the SCC decision, or is it final?
This is it. No, the Supreme Court of Canada is the final decision maker on this. There is no appeal. But as I tried to make clear, this decision deals with the constitutionality of this particular act in the way this act is structured and framed, right? In the way it's precisely written. That's the way courts approach constitutional issues of this kind. So changes to the act, reenactments, perhaps some of the regulations that implement the act may still be subject to challenge. But the fundamental constitutionality of the act as it stands right now has been finally decided by the Supreme Court of Canada.
Is there a plan now to review some of the individual provincial models post-SCC decision? In particular, Quebec cap and trade with California. For instance, can other provinces go this route?
There's some issues about the backstop and recognition of provincial legislation as equivalent still on the table, including Alberta. Mr. Kenney has got to decide what he wants to do. My impression is that he and his caucus, if they are still capable of getting together on anything, are not that pleased with the application of the federal legislation within Alberta. Okay, so it is open to him to enact his own legislation. They can certainly, the UPC can certainly do that. But for one thing, they would be going back to territory that the NDP previously occupied with its Carbon Tax Act. And right, the government made a big show of repealing that act and getting rid of it and freeing up individuals from damaging price increases at the gas pumps and so on. So there are factors of that kind that they will undoubtedly take into account. The other thing is if it's Alberta legislation, under the federal legislation, the price is scheduled to rise significantly, right? It's at $40 a ton right now. It's scheduled to rise to $170 a ton by 2030. So that's going to be the benchmark, the equivalency benchmark. And it's not going to be easy for Alberta to do that because of the emissions of the oil and gas sector, and particularly of the oil sands, right? It's going to be expensive for the industry to even come close to meeting those emission standards. And I expect that that's part of the advice that the Alberta government is getting right now about what it should do, and particularly whether it should adopt its own its own general greenhouse gas pollution pricing legislation. New Brunswick, for example, adopted its own legislation I think several years ago, I think in 2019, and its price is lower than the federal price. And at the same time, it reduced the gasoline tax within the province, right? So that was a gift to the citizens of New Brunswick, and that was accepted as equivalent by the federal government for the purposes of the Greenhouse Gas Pollution Pricing Act. And at the time, people wondered whether the federal government was really bending over backwards to try to reach an agreement with New Brunswick, and perhaps went too far in accepting that kind of arrangement based on prices that were actually lower than the federal minimum price. So something like that is a possibility, but my take on that is that today, and particularly in light of this constitutional decision, the federal government is in a much better position to say, okay, national standard minimum price, that's it. And the ball is back in your provincial court. So those are some of the things that the Kenney government is going to have to think about and decide. Some of them are economic, but you can see that some of them are obviously political.
Has the SCC's determination that the carbon tax is not in fact a tax opened the door for the provinces, not the federal government, since its taxing power is not limited, to enact regulatory measures that involve regulatory stipends not going into provincial general revenues, but instead being rebated?
The NDP's carbon tax act did not rebate the tax, but put the bulk of it, at least, into clean tech initiatives of various kinds. So that kind of approach is definitely available. Legislation of that kind could also simply be set up to directly rebate the revenues that are collected, but that's an approach that really seems to grate with the UPC government as a technique, right? So first of all, it looks like a tax, no matter what you call it, and it leaves the citizens of Alberta wondering about how this is actually working, because they will be able to see the increases at the gas pumps, and yeah, there will be a line on the provincial income tax that shows them the rebate they're getting, but people are going to wonder about the effectiveness, right? The extent to which that kind of regime will actually change behavior, right? And you have to ask that question about this kind of legislation generally. It's something that seems to have been accepted internationally, that this kind of legislation actually does affect consumer behavior to a significant extent and result in lowering emissions in the longer term. So I guess what I'm asking is, does that actually work in Alberta?
Okay, there are currently no more questions in the chat, so we still have a few minutes left. If anybody does have any more questions, now's the time to post them. Or I guess if we want to be more interactive, feel free to unmute yourself and ask the professor a question that way. I think you've covered it all, Professor.
Well, as I've said, this isn't the end. This isn't the end of this, and there's definitely going to be tinkering with this legislation. A lot of the action is going to be on the tech side, right? So we've got the Greenhouse Gas Pollution Pricing Act itself, and the federal government has now committed to carbon neutrality by 2050, whatever that means. And there's debate about that. In fact, um, the Canada Energy Regulator released a report last fall that discussed uh, uh, carbon neutrality in some detail in the energy sector, and that seems to be part of the federal ambition pointing to this kind of approach to greenhouse gas emission reduction. And there was a whole suite of well, there's a chunk of money, a large chunk of money, many billions of dollars in the recent federal budget to support clean tech initiatives of different kinds, including things like renewable energy, electric vehicles, and so on. So there's a sort of multi-front approach that the federal government is taking. But if you look at Canada's situation as far as meeting Paris Accord targets are concerned, the sticking point is the energy sector. There's little doubt about it when you look at the extent of emissions. More than 25% of Canada-wide GHG emissions come from the energy sector, and that's a big chunk. And the energy sector contributes close to 6% of Canadian GDP, and so that's something that the federal government can't ignore as well. Right, so you can see how this is shaping up. The federal Alberta standoff is not likely to end very soon on this.
What might happen if CO2 was reclassified as being non-hazardous?
As I mentioned, this has happened under the Canadian Environmental Protection Act. I guess right now that wouldn't really make any difference because the federal government has decided not to use that route, that is the Canadian Environmental Protection Act route, to regulate greenhouse gas emissions. Since I've been looking at this, starting about 20 years ago, that seemed like the most likely possibility, that greenhouse gas emissions were going to be regulated as a quote unquote toxic substance under SEPA. But the approach now is much more a fiscal approach, right? And ultimately in this reference, that's what the core factor was for the court. So it's national standards, national minimum standards of greenhouse gas emission price stringency. So these are pricing standards. So that is the approach that the federal government has opted for right now. So I think the idea of treating greenhouse gas emissions as a toxic substance, which in principle might still be viable, has really been put aside by the federal government.
All right, we actually do have 2 more questions in the chat, and I think we'll probably wrap it up after that. First question, I believe you mentioned that we might hear more of the concerns raised in Justice Cote's dissent. When and where will we hear more of her issue?
This is a broader problem in public law, and some of you may have encountered this in totally different contexts. This is the problem of governments passing framework legislation that sort of outlines the purpose and intent of the legislation and makes grand statements, and then gives very broad regulation-making powers to the executive, whether it's provincial executive or the governor and council federally. And what that means is that the guts of the legislation and its implementation then is done by way of regulation. That is a much more closed process. It's not subject to the kind of public debate that the bill itself would have been subject to. So it's a rule of law issue more than anything else. And so Justice Cote is picking this idea up and applying it in this particular context. So you can think about that. I've certainly encountered this in many contexts in the energy and environmental regulation field, where you can read the statute, but you are not very enlightened until you plow your way through acres of regulations to try to figure out what is actually being done here and what the requirements actually are.
All right, and then our final question for the day. Is there any mention of cooperative federalism in this case, and how did it affect the result?
There's half a paragraph in the majority judgment that refers to cooperative federalism, but Chief Justice Wagner basically says, yes, we're all in favor of cooperative federalism, but cooperative federalism really can't override what the Constitution says. I'm paraphrasing, but that's essentially what he said. So that takes you back to the idea that if anything, cooperative federalism has relevance as an interpretive factor when it comes to interpreting the Constitution itself and perhaps interpreting the legislation that's an issue in the case. So it's an attractive idea, but as far as this court is concerned, it doesn't go very far in terms of constitutional analysis.
All right, thank you. Thank you everyone for your questions. Thank you for answering, Professor. Thank you all for spending your Saturday morning with us and for supporting the Canadian Institute of Resources Law. Thank you to the Alberta Law Foundations for sponsoring today's workshop. Of course, a big thank you to our presenter, Professor Emeritus Alistair Lucas, for delivering such an insightful overview of this much anticipated Supreme Court decision. It is always a pleasure learning from you. Later today, you're all going to receive an electronic evaluation form, and we kindly ask you to please take the few minutes to fill it out, as it really does help us out. And our next Saturday morning at the law school session is currently being organized. It will either take place in June or July. So that event will be up on Eventbrite soon, as well as emailed out to our mailing list. And we hope to see you all there. And that concludes our workshop for today. We hope you all have a safe and wonderful weekend.
Thank you all.
Thank you very much for this. This was very informative.
Thank you.
Great review of constitutional law post finals.
Great, thank you very
Yeah. Thanks, Catherine.
Brought back some traumatizing memories. All right, goodbye, everyone.